Good Saturday morning to everybody, and welcome to Legal Notes with Mary Ann Charron and Ned Barron. I am Gary Byron. Good morning, my friends.
Good morning.
How are you?
Ned? Dun-dun-dun.
I'm doing great.
Let's talk about if it's a good idea to jointly own assets with a family.
So one of the things that...
Well, let's define family first.
Oh, all right, go ahead.
Yes, you're right.
There you go, Ned.
Spouse?
Yeah?
Not a bad idea at all.
Depends.
In most cases. Well, in most marriages that spouses do jointly own assets.
Right.
Bank accounts, investment accounts,
Yep.
the house, cars, stuff like that.
Yeah. Hopefully if you married that person, you trust them and love them. Yeah,
I think in the context of jointly owning assets with family members, that jointly owning an asset with a spouse has a lot less pitfalls than jointly owning assets with other types of family members. Unless
it's a second marriage.
Well, yeah, but let's not complicate it right now.
Oh my God.
Are there a lot of second marriages? Are there,
Oh, yeah. 50% of the marriages end up in divorce? A lot of people try it again. So
it's probably more than 50% now, isn't it?
Might be. After COVID, people couldn't handle being next to each other for that long. maybe divorce has increased. I don't know. So
I think there's some stat that's that point, though.
Mm-hmm.
Really?
Yeah.
Well, because the courts weren't open, I would have said it had decreased.
You can still file.
Sure.
You could file.
Well,
so family court was one of the few courts. Probate courts and family courts continued to operate during COVID. But yeah, right? Isn't that what Kelly Clarkson, that was what she said? She just couldn't handle. They realized how different they were when they were stuck together during COVID. And that was one of the reasons she cited for her divorce.
Oh, is that why? She realized they were so different.
Yeah.
It's not because they were getting sick of each other.
Well, maybe they were, but, when you're stuck in that small period of time. But, Ned is correct. Jointly owned assets, you think the least amount of problems relates to when you jointly own something with a spouse, which is normally real estate and bank accounts, for example, investment accounts sometimes, right? So you put all your assets together, you're married, and so you jointly own them. And you're right. That tends to have the least amount of problems. The greater number of problems is when you jointly own, like you and a sibling think it's a good idea to buy property together, or you and a sibling inherit property from your parents, you jointly own it now. You decide that you want to jointly own assets with your children, and those are ripe with landmines. Pitfalls, landmines, or things like that.
Yeah.
So
parents and children are
probably the number one.
When I think of what are the worst cases that involve family members jointly owning assets, it's parents jointly owning assets.
Yeah.
The question is well, why would a parent jointly own assets?
Yeah, we get that question a lot. One of the things that people come to us and one of their priorities is to avoid probate, right? So they're like, how do I avoid probate? I want to make things easy for my family. And Ned and I would never say that is a bad goal. It's a good goal. And we help people all the time with that. So then the next thing is you can have a trust, or, there's vehicles by which to do that. And then the next thing that people regularly say to us is, well, what if I just, give everything now? What if I just add my child to my bank accounts? What if I just transfer the property? We get requests all the time. Sometimes it's from the children, but mom wants to quit claim the property to me, or I want to transfer the property to my child.
Is that to avoid probate?
Yes. Most often it's done to avoid probate. Sometimes it's done to avoid Title 19. And as you've learned, Ned and I have discussed in prior radio shows that Title 19 is very complicated, and it's not always a very good strategy because there's a 5-year look back. So people come to us all the time, and we have to explain to them why that isn't always a good idea. Ned's experience has been with, and we have too. I mean, if there's something that's been litigated, it has to do with jointly owned assets. And both of us have had that experience. Your experience has been with children, family members. I have had 2 trials where the parent added a neighbor for convenience.
Really?
Because the children no longer lived nearby, added a neighbor, and the neighbor was claiming that all of that money was theirs. And
all?
Well, so when you have a jointly owned asset in Connecticut, a bank account, for example, that the legal presumption is that the surviving co-owner is now the 100% owner of that asset. And unless when that account was created or that person was added, let's say in that case of the neighbor, when they were added, if the owner of that account did not make that distinction with the bank to say this is for convenience purposes only, right? That if there was not that designation, the convenience being, I need help. I'm elderly. I need help paying my bills. Someone to help me write the checks out. I can sign them, but just to help me with that. And there are, good Samaritan neighbors who have helped out their neighbors. There are also not so good Samaritan neighbors who
pray
themselves, to help by helping out their neighbor. And so, again, if that distinction is not made at the time of adding that neighbor onto that bank account, or it could be a child, then at the death of that person, that surviving co-owner can now just empty out that account. And because the presumption is that they were a co-owner of that account. And so,
if you don't mind, I just you touched upon something that is really important. They can access that money at any time.
True.
All right. So it's really important. So when you talk to someone and they say, well, I want to add my child on the bank account, and they go to the bank and they add the kid to the bank account, that kid has the ability as if they own the money and can withdraw it. And both Ned and I, right? I mean, just like you and your wife have a joint bank account. You don't have to both sign a check for every time there's a withdrawal from your bank account.
Correct.
She can take money out. You can take money out. All right. So it's no different. And both Ned and I have seen circumstances when the money has been disappeared.
Wow.
Yeah. And
you have to get the police involved, or?
Certainly. Well, some parents don't want to. I mean, it's up to the parent. And the thing is, the bank had every right to allow that person to withdraw the money. They were a co-owner, right? So you could get the police involved, but the police are like, they legally have a right to this money. You added them. So, hopefully they didn't go to the casino and gamble it. Hopefully they didn't go on vacation with it. In other words, those are examples of when the money is gone and no longer accessible. Maybe they just transferred it to their own account, and we can then go after them if the parent or the co-owner so chose to, for the unlawful transfer of the asset. But you mentioned it, and I just wanted to make sure that's not the only time at person's death where you get the money. Certainly it is true. But once you add someone to a bank account, they have access to it just like you do. And it's really important.
Yeah, I think the cases, at least that I'm aware of, the cases where the issue has come up during the life of let's say the elderly person whose account that was originally, that's less than the case at death. And the reason why that is because if that person who is elderly and in need of help and asks the neighbor to help or a family member and adds them on, they're still hopefully active in the management, but they're still reviewing their bank statements. And if they see they've been cleared out, then something could hopefully be done about it pretty quickly. But sometimes, I mean, boy, we're kind of touching into financial exploitation of the elderly.
That's exactly right.
And we're getting into the psychological aspects of that because we have definitely known elderly people who have been financially exploited and are so embarrassed by it that they are not telling a soul. And I know it's
correct.
happened to me, but I'm sure
not
it's happened
anyone's
to you.
exploited you because you're not elderly.
Not yet, anyway.
Right.
But
No,
yes.
but I think it's happened to both of us where actually a client has confided in us and they've said, but don't tell my kids.
Don't tell anyone.
I don't want my kids to know that I got scammed by, and I know we're a little off topic, but I think and maybe this is really great for people out there to hear, is that if you ever get a phone call from somebody purporting to be a grandchild of yours or a child of yours saying, I'm in San Diego or wherever, and I got into a car accident, and I'm in the police station, and I need you to send me $10,000 right now. You need to confirm,
to help me get an attorney or whatever it is,
or to pay the bond, to pay the bond, right, or anything, bail. That think twice, because we have heard cases.
Yes.
I've talked to people who said, I swear, I thought it was my grandson, and the only thing that was weird was that he didn't sound like him, and I said, Joey, how come you don't sound like you? And then Joey says, I'm doing air quotes right now, says, oh, well, when I got in the accident, my face hit the steering wheel, and so my mouth is swollen, and that's why I don't sound like. Mm-hmm. But these scammers out there know, I mean, in this case that I was just referencing with Joey, that Joey says, don't tell my parents, because he's the grandkid. Don't tell my parents. I don't want, they're going to get mad at me, and my client ended up sending, I think, $10,000, never to be seen again.
Right.
And the thing was that they knew enough about his family and the names of his family members, his kids, his son in this case, and or his daughter in this case, and his grandson.
Yep.
So they were able to scam him out of this money, and this happens all the time.
Yeah.
And so I'm just letting people know out there that who are listening.
It does.
That if you ever get that phone call, you need to verify in some other way than just to believe in the person that's calling you. As much as your heartstrings are being pulled, as much as
I've heard of those scams, and it's just sad when they prey on the elderly, and it's
they're
sad.
so good at it. I mean, I had someone for whom I was the conservator, so I managed his money, and he called me up, and he asked almost the exact same scenario. It was a neighbor, a good family friend, the child, and I said, that's a scam. He said, no, it's not. And he was screaming at me, telling me that I was the only reason why he wasn't helping a good family friend and child and needed it. And if I wouldn't help him and give the $10,000, I said, it's a scam. You need to understand that happens with such frequency that it's just so sad. So yes, there are scammers, which are not the same as co-owners, but
the point I was making was that this happens all the time, and when they figure out that they got scammed, they are so embarrassed.
Yeah, they don't
want to tell anyone. Not only that, but they're also afraid that if they tell somebody, they're gonna be told that they can't manage their finances anymore.
That's correct.
That they now I've been they're unable, right? They don't have the capacity to manage their own affairs, and that just will give someone the opportunity to take away their rights.
Yep. So, I have seen, both Ned and I have seen family members take money. Oftentimes, the circumstance under which we discover it is when there is no money, the care is needed, and we get called because we have to apply for Title 19 for someone who needs care. And you start going through the bank accounts, and you see withdrawals of some significant sums, and you then have to determine who got the money and how did that happen. And you find out that there was, and Ned is correct, it's usually a child, a family member. Both of us, we were involved in a litigation a couple of years ago where it was a neighbor, but and the money was gone, never to be seen again. So the thing is, when people come to you, generally, when people come to you, they still have some level of capacity, and they do say to us, well, okay, thank you for telling us that story, but it's not going to happen to us. But it can, and it does happen. oftentimes Ned and I think we've talked about this before, if you want to call it intuition or just the years of experience, when a child brings the parent in and says, well, why can't they just add me to the bank account? Right? Mm-hmm. Make things easier. And then, you can start to feel the little bristling on your arm hairs kind of thing. And you start to go, well, that's true. However, right? And ultimately it's the parent's choice, but it's important to educate people that there are significant risks when you add someone to your bank account. And, I was talking to, when Ned and I were preparing for the show today, I was reminding him of my recent litigation where I had someone who did add a neighbor, and the account had like $300,000. I mean, a significant amount of money. In fact, it was the majority of all of his probate assets. He had 4 daughters. None of them, the family was divorced. So originally they were in Florida. All the girls were still in Florida. And, he was still here in Connecticut. And so he added the neighbor, and the neighbor's position is that money is mine. And I ended up representing the 4 daughters and to go after that account and said, no, you were added for convenience only. You are not, that money is not yours. It never was yours. It was always his. And, I did have to take that to trial. So it does happen. So the general rule that everyone should know is that a co-owner, when someone dies, when one of the owners dies, the co-owner gets the money. There are, however, some protections. The burden is high where you can demonstrate that was for convenience only. But it requires litigation, and it was not cheap. Let me tell you, if that was a lesser amount of money, I don't think these daughters would have paid me to litigate it, because it costs an awful lot of money to take something to trial. But that's bank accounts. I did want to address the real estate.
Let me just give you 1 second. I want to do an ID here. Folks, you are listening to Legal Notes with Mary Ann Charron and Ned Barron. I'm Gary Byron. You can check out their website at charteroaklaw.com, and you can write down this phone number if you'd like to make an appointment, 860-570-1229. Okay, go ahead.
So I wanted us to talk about the real estate briefly, because I realize we don't have a ton of time, about what happens when you add a child to real estate.
Okay, let's do it.
Yeah. Well, so going back to the idea of avoiding probate is probably one of the biggest reasons why. So the scenario would be husband and wife, had kids, the husband passes away, let's say, and that now that the mother, we'll call her now, is now the 100% owner of the house. And we have families that come to us that say, for several reasons, well, one, let's get the house out of her name, or at least add somebody so that when she dies, we can avoid probate. Or let's transfer the house to a kid right now to avoid, the Medicaid or Title 19 spend down, right? So we can start sheltering those assets from her long-term care needs. Okay, in theory it sounds good.
Yep, that's right.
But what the problem is that there are major pitfalls. As soon as you add someone on as a co-owner or as the 100% owner, but let's do co-owner for a second.
Yep.
That now it's looked at in the eyes of creditors and anyone else out there that they are now a co-owner of this asset. Okay. So now it's an asset of theirs too. So if they either are in financial difficulty or get into financial difficulty,
creditors,
right? They get sued.
Yep. Creditors can attach that interest.
Creditors can attach, right? They can attach that property. Bankruptcy, the court can force the house to be sold for let's say if it was one half of the proceeds go to pay the creditors,
and creditor can foreclose.
Right. Yeah.
So now you have a parent.
Mom
so you go
is out on the street.
You go to bankruptcy?
Well, let's say the child had to file bankruptcy for whatever reason, right? So what Ned and I are trying to say is, you as the parent add your child to the real estate, right? So that's it. That's it. Recordable interest. And now that means the world knows that you own an interest in real estate. your creditors can attach that interest. If you file bankruptcy, that's an asset that the trustee is allowed to utilize to divide to your creditors who you have, right? Someone can foreclose on your interest. And so it becomes really dicey for the parent who lives there, who really owns it, who transferred it out of love or out of trying to avoiding probate. And I have had to deal with the sad situations of saying, okay, you could lose your house now. I have had circumstances, I think you have too, Ned, where Ned just addressed a co-owning, but what if you transfer the house outright to that child? I have had children kick their parents out of the house.
Are you kidding me?
I am not kidding you. I have had parents evicted. Mm-hmm. Mom.
Or partitioned?
Partitioned action is the same when you have co-owners. And so I have, when you go to court, when someone tries to force the sale. So when you have a child who says, you know what, Mom, this isn't working anymore. And this is half my house now. I want it listed for sale. I need the money.
You can force the other person to sell.
You can, and it's through a partition action. Yep.
Right. And the person is going to have to sell.
Yep.
If the court, the judge allows it. But.
If the judge allows it. And,
Can you sell just your half?
Well, to who?
Oh, right? Somebody wants to buy it. I don't know.
No, someone could. It's at a discount. I mean, I suppose you could. You could say, you know what, sell your half and I'm here. Right? But you're still subject to whatever those rights and responsibilities
are. So what happens
are.
to those assets when you die?
Yeah. So, go ahead.
I think you said the co-owner would get it, right?
That's the general rule.
Right.
I think you said that a little while ago.
Yeah.
So unless.
But do they have to share it with other family members?
No.
Oh.
Absolutely not.
Right. And that's one of the situations that's particularly awful. There was a case that I remember from a long time ago, but where there was a gentleman, he was a farmer, had a working farm, simple guy, and then he retired. And so there was a lot of land, and there were three kids, and the daughter was the one who was there helping him out, and she was kind of what he considered the responsible one that was helping him with paying his bills and stuff. And so he thinks, it's a great idea to transfer the farm to her with the provision in, verbal provision,
right,
that she's when after he dies, she's going to split it between her and the other two siblings. And she said, "Oh, of course, Dad, I'll do that." Father dies. Daughter says, "It's mine.
It's mine.
Left to me."
And that happens all the time. It happens with bank accounts.
Are there any exceptions to that, or?
Well, it gets back to whether it was done for convenience only, and there is a statute. You could litigate it. It's a very, very tough burden. I think it's even tougher when you transfer real estate, truthfully. I mean, than it is for a bank account. It's a little easier. But it happens all the time. I've left money in an account for my funeral, and my daughter's going to take care of it. And daughter's like, that's my money. Somebody else can pay for the funeral. Happens every single week.
That's sad. That's got to break your heart.
So, and the other siblings are like, what are you talking about? What? That money was Mom's. It's not yours. Mom gave it to me.
Yep. And actually, that is a really effective defense for someone, whether they took money during the lifetime of the person or it was given to them at death, like the neighbor, right? Oh. That the bottom line is that here's the defense. It was a gift.
Such valuable information this morning. It's a wealth of knowledge that we all need to know. Folks, if you've got questions, they've got answers. Check out their website, charteroaklaw.com. Again, www.charteroaklaw. And if you've got any questions pertaining to this show or any of the other shows from Legal Notes and Charter Oak Law, give them a phone call, set up an appointment, 860-570-1229. Once again, it is 860-570-1229. They've got offices located in Bloomfield, Danbury, and Norfolk. You could also email them at legalnotes@charteroaklaw.com. For Marianne, Charron, and Ned Barron, I'm Gary Byron. Until next time, have a good one, everybody. So long.